The courts actually provide a glue to a stable society. Justice Yonny Kulendi of the Supreme Court. In the system of justice that the people of Ghana have adopted for themselves, which is adversarial in nature, the judge is essentially a referee. However close the referee is to the ball, and the ball is to the goal post, the referee cannot kick the ball. Justice Yonny Kulendi, he's right here with us for the second installment of our education series on a court of competent jurisdiction. And remember, we have outstanding questions about the specialized nature of the high courts. Why is the Supreme Court also not in divisions as you find in the high courts? Why are there delays in the system? He spoke about the question of trust, which is very essential for them to be able to deliver their work and be as accountable as the people expect. They have taken some bashing. How justified are they? But how do they go about judging? Very important. I'm Samson Lardy Anyenini. This is the law. It's your legal lights. It is your health law. We'll be right back.
The leadership of the judiciary for some time now has been engaging the idea that we need to do one step further. At least, we'll not make everyone a lawyer, but if everyone understands what we do, how we do it, why we do it the way we do it, then we'll be better stewards of the people on whose behalf we exercise justice or administer justice. Who are you when they say you are a judge? You're actually a trustee and a servant of the people trying to administer justice in their name, for them, and on their behalf. And so at best, the judge in all that decoration is a decorated servant of the people, exercising trust power which doesn't belong to the judge or the court, because sovereignty and justice emanate from the people. Judge is a judge is a judge. So in terms of the software that you need, the ethical base, the core values, which being a person of high moral standing and proving character speak to, that software, whether you are sitting in the lowest court or in the highest court, is the same denominator, because a dishonest man should not come anywhere near the sanctuary of justice, even at the most basic level. It's been a rather unfortunate castigation, judgment, indictment of judges in the judiciary. I didn't realize how the extent to which judges are bastardized and spoken about in lowly terms and with suspicion until I became one. Okay. And then I was like, oh, is this what I really bargained for? And sometimes, more often than not, is all inflamed by misunderstanding, lack of information, lack of the education on what we do, how we do it, what the rules that they, the people, have provided for us, allow us to do, etc., etc. And where there is, for want of a better word, ignorance, then there's a huge potential for those who are up to mischief to manipulate the system, to incite the people, and position people to have an anti-court, anti-due process, anti-judiciary posture.
You're welcome back. This is the law. It is your legal light. It is your health law. The courts are accountable. Judges are accountable. You were told last week. Now, if you don't remember anything, we gave you a sneak peek of a recap of last week's. We know that there are millions who are watching home and abroad. And we're excited to know that on Monday, another equally huge numbers of you watched again. And on YouTube, last time I checked, some 9,000 plus of you have gone there to watch and can watch at any time. So remember, the judge, in all their decorations, is a decorated servant. One of you asked a question. I'm putting that question to him on a lighter note before we start. You said, if they are our servants, how come we call them lords? Justice Yonny Kulendi, thank you very much once again for making time to join us. How do you answer this questioner?
Why the servant is called Lord? I think that the answer is both in history and in the context of the Constitution. I mean, historically, we take our legal tradition from the common law. And as we all appreciate, the common law is headquartered and evolved from a monarchy. And so to date, the British Parliament used to be called Her Majesty's Parliament. Now it will be His Majesty's Parliament. You realize within in hours of the succession, everything changed from Q to K. Everything belongs to the king, so the parliament is the king's. Even council at a certain level becomes a king's council. And so because of monarchical status, and so judges were actually appointed or selected or designated or given their warrants by the crown. And so I don't know anybody who sees the Otumfuo or Yana or Gamanches representative sitting in a chair that constructively is the Gamanches seat in judgment, or the Otumfuo seat in judgment, or the Yana seat in judgment, or the Nairi's seat in judgment, that you will not accord by extension the courtesies and respect that you would have accorded to His Royal Highness, His Majesty, Her Royal Highness themselves if they were in that seat. And therefore, judges as agents and representatives of the sovereign king, by extension, got a reflection of this high courtesy and respect that you would accord to the principal on whose behalf they do this work. And so I think I should say, and that as representatives of the sovereign people of Ghana, who we have been arguing are the real sovereign, that the Ghanaian people are the heart and the center and the owners of power, all powers of government, from executive to legislative to judiciary. We do it for and on their behalf, in their name, and for their benefit and the common good. And so I would assume, I would extrapolate that for the same reason, judges who sit as agents of the sovereign, by extension, even if we didn't have this history, will be accorded the courtesies and the respect that you will give to the messenger of a great people, the Ghanaian people.
Right.
Yes.
Thank you, and I hope that education was good for you. And there's a lawyer who extended thanks to us and said he had actually not averted his mind to the fact that the judicial committees, councils at the House of Chiefs, the National House, the traditional, regional, constitute a part of the court, and they are part of the structure of the courts of Ghana. And he was hearing that for the very first time. Thank you. So it is not only those people we can say they are legally illiterate that received education, but almost all of us did. You were told some basics. I'm just recapping this before we go on. And remember, today we'll have opportunity for you to call in and ask your questions. We'll have some extra time for you to do that. The judges were explained from the lower to the superior courts. The courts have been divided into lower and superior courts. And he explained the lower court, what he said inferior. Not inferior in terms of anything, but because of the limitedness of the power that is given to them to do what they have to do. At the district court, a lawyer, 2 years onwards, then you're qualified. The circuit court, 5 years, you're qualified. That is only in the years of experience as a lawyer, which he called the technical. And then there is also the software. Then at the High Court, 10 years. At the Court of Appeal, 12 years. At the Supreme Court, 15 years. If you don't have these years, you are not qualified at each of these stages to become a judge. And then he told us about the overriding consideration, which he said is the software. Everyone needs it, irrespective of the years you have, that you must be a person of high moral character and proving integrity. Then, when it came to the court, he explained to us their jurisdiction administratively and what he called criminal and civil jurisdiction. And in the civil one, he explained also to you that for the district court, he called something the money cap, which is from 0 to 500,000. And then the circuit court from 500 to 2 million, they can handle a case there. That is for civil matters, that's the money cap. And then we got to the High Court where he said up to infinity. They, in the civil jurisdiction, they have no cap. Now we were asking the question, why is at the High Court, there are divisions, labor, commercial. Why is that so?
Samson, to come to that, there's actually even some element, if you want, of division, or call it specialization, at the level of inferior courts, because below the magistrate courts, you have juvenile tribunals. And then it is also, for the same reason, in some jurisdictions, you will even have rent courts. It's for the same reason, and you would realize lately we've had courts that deal with enforcement of SNIT, social security.
Particularly Saturdays.
Exactly, and they actually sit on weekends because we want to free employers who are culpable to have a productive day and still answer to their statutory obligations. And then, of course, you then also have the traditional councils of the houses of chiefs. If you pay attention, is the recognition that there are specialized and complex social issues that require, if you want, peculiar rules, peculiar skills and attention, even peculiar procedures adopted to suit the need of society. Now, the level of the High Court that has jurisdiction in all matters, civil or criminal, and of course also including appeals from district courts, as well as a responsibility to supervise the lower courts, because we said that the function of competence is that what you set out to do must have been authorized, mandated, and power vested in you as a court to deal with it. So you have a subject matter, and within that subject matter, you have scope, you have caps. So when you exceed some of these caps, the High Court serves as, if you want, a school prefect over the lower courts. And whenever they purport to do something that breaches any of the fundamental considerations that go to competence, you don't waste time ventilating that through the appellate process. You go to the prefect and say, Magistrate A has purported to exercise a power that it doesn't have jurisdiction to exercise. And if you can satisfy the court that the judge was outside his authority vested by law, then whatever the judge purports to do would be declared as null, void, and of no legal effect.
That's what you call judicial review.
That's judicial review. So the High Court exercises judicial review over the lower court.
Great.
Then, of course, because of the pride of place and priority we give to fundamental human rights and freedoms under our Constitution, the responsibility for enforcement as a court of first stop is given to the High Court as a superior court. And it deals with everything to do with the enforcement breaches of the fundamental human rights provisions of the Constitution. So if you look at how huge the whole scope of human activity, civil, criminal, human rights, supervisory, etc., etc., even though a high court is a high court is a high court, and technically there's only one high court in Ghana. There is only one high court. It just sits as divisions and in different quorums where you have different judges, but there's technically only one high court subject to those divisions. Administrative divisions are then cut out to deal with specialized areas of the law. So let's say land.
Okay.
So you then have a land division. And there are a number of, so if you go to the 43 high courts that are in the court complex, you'll see that a number of them are dedicated primarily to dealing with land matters, and that will be called the land division. Now, but they are high courts, right. And it doesn't also mean that they cannot deal with any other matter cognizable under the jurisdiction of a high court. It's just administrative convenience.
That's important because recently there's been a misconception by certain people that a criminal court was dealing with something else, or some other court was dealing with a criminal matter.
Samson, obviously a big mistake, and that is why at this point it's important of note, which is that there is one high court in Ghana. That one high court sits in different quorums, which is the judge sitting, and may sit in different administrative jurisdictions. But a high court is a high court is a high court, and every high court, however designated administratively, has the same competences as a court of competent jurisdiction, right, to deal with any area. So it's administrative convenience that judicial administration, the Chief Justice, will constitute a land court, have a court for matrimonial causes that deals with the peculiar problems of romance gone bad, families, and because these are very nuanced and difficult problems. There is a financial offenses court. Then there is a commercial division of the High Court. I'm sure that going forward, as our economy gets sophisticated and the activities get more and more complex, even within the commercial division, it's conceivable that the Chief Justice may be able to constitute other divisions depending on the needs of society as she feels the judicial administration of justice is called on to deal with.
There's a labor and industrial.
And then there's labor and industrial that deals with industrial issues and disputes relating to employment, etc., etc. And there's actually a human rights division that deals with human rights related causes of action. It doesn't mean that the human rights division is not competent to deal with a commercial case. It is competent to deal with it. It will use the High Court Civil Procedure rules, and that's why there's one Bible that every High Court judge will use in terms of their procedure, and that's the High Court Civil Procedure rules, wherever you find them. And any High Court that is dealing with a criminal matter, its primary procedure source will then be the Criminal and Other Offenses Procedure Act. It's the same Bible.
Okay.
So it's put it to different denominations all preaching the same Christ, or different masjids or mosques all praying to the same Allah. So it's just administrative convenience to better address and serve the needs of society that occasions the divisions of the High Court. Right. But they are all essentially the same High Court. Now, and let me make this point. Now again, but because these administrative needs, imperatives, are not taken lightly, for instance, even though a high court is a high court and is a high court, the courts will frown on a party who wants to sue because there are other procedural rules in terms of where to sue a person. You want to sue a person who lives in Tema or in Kumasi, and you go and sue the person in Bolgatanga High Court. Or you want to sue in relation to a land that is in Accra, then you go and commence the suit in the Takoradi High Court because a high court is a high court is a high court. We have a rule on which venue is the most convenient venue for dealing with a particular matter that the court may well have jurisdiction and competence to deal with. And so if you went to the wrong venue, the suit will be impeached
and transferred.
It will be remitted to the Chief Justice to be placed before. So it will not be, and I see lawyers make that argument, it's not a jurisdictional argument.
Right.
It is an argument about the venue, which is the most convenient venue to go to ventilate.
You say the life of the law is experience. And I went through that once. I've learned it once. I will not make the mistake again. Right. Okay.
Yeah.
Thank you very much. If you're just joining us, this is The Law. It is your help law. It is your legal light. And we have Justice Yonny Kulendi of the Supreme Court once again assisting us with this very important education, empowering all of us so that we know how to go about what we have to do when we are dealing with the court. Remember that he's begun by telling us an essential part of the court, a checks system within the court. Last week he took us through that, but he has reaffirmed this, a check system. And the High Court serves with supervision over all the courts low below. And so let's take a note about that. So I was interested, and people are also interested. They are saying there's been calls for the Supreme Court to also be divided in similar fashion. Why is it that we don't have that?
One is a number of reasons. So Samson, if you, at last count, for instance, there are across Ghana, I believe about 125 high courts across Ghana. And the Chief Justice is still commissioning and opening more high courts because technically every region should have a high court at the very least. And depending on the size, population density, distribution, etc., because there are issues of access to justice which are constitutional and fundamental. You can have, in Accra alone, you have several high courts. That's why I say the court complex alone houses 43, 45 courts, and there are high courts from Adenta to Amasaman to Weja, Tema. Even Tema alone has 3 or 4 high courts. Now, so if you look at even the share number and scope of activity, then it is practically feasible to afford the specializations, if you want, the subdivisions for administrative convenience. But the Ghanaian people say, when it comes to our apex court, the highest court of the land, we want that court to be made by X number of justices. And you can see that we have been back and forth about whether or not there should be a ceiling, because the Constitution simply says that it should be made by the Chief Justice and not less than 9. Now, so if there are 15 or 17 justices of the Supreme Court, and you wanted to create divisions of the court, how many divisions are you going to create out of a court of 17 justices, whose minimum to form a quorum is 5, in dispensing the ordinary course of business of the court? If you come and meet 3 2, 4 judges of the Supreme Court sitting, they can be doing anything but not exercising their jurisdiction. They will not be a court of competent jurisdiction. To be competent and be a court properly so-called, the minimum number is 5. There are exceptional interlocutory matters which you can go to a single justice of the Supreme Court, but even you would realize when that single judge takes a decision that you are unhappy with, the law then allows you to go to 3 judges.
Right.
But normal quorum is 5. Mm-hmm. In constitutional matters, because of the gravity and the weight we put on them, the Constitution says minimum 7 or 9 or 11. So if you are going to create divisions, are we going to appoint more judges, or you'll have those same 17 or 18 or 15
because
judges?
The divisions will not have to be presided over by one judge.
At all. It will always have to be, for it to be the Supreme Court, you need a quorum of 5 for everyday business and 7 minimum for any matter that is constitutional. And when it comes to the review jurisdiction, you will add another 2. That's number 1. Number 2, by the time that you get to the apex court, you're generally deemed in terms of technical competences to have gained experience, mastery, understanding of the law across the entire spectrum. You may have your edge, you may have the things that come to you with relative ease as a judge, but you will not be found wanting in any other aspect of the law. I mean, if you have that deficiency, then you are not fit and proper in terms of the competence requirement.
Right.
And so the presumption, and it's a right presumption, is that by the time you get to that apex court, you are a grandmaster of the law. And so it doesn't matter what area of the law is concerned. If you sit yourself down with the aid of your research resources and all of that, you pull up the basic principles, you can unlock the nitty-gritty and the issues that arise in that case at that apex level.
Right. So those who make the proposal, including now the director of the Ghana School of Law, Yaopong, have been saying that the Supreme Court has too many jurisdictions, varied jurisdictions, and there is too much work, and yet you are not enough. So why don't you hive off a part of what you do and say create, like we have in South Africa, a constitutional court?
I mean, it's an option. There are countries that have just a constitutional court that deals with only matters in relation to the Constitution. And then they have a Supreme Court that may be that's the apex court. Then there are also countries that have Supreme Courts that double both as a constitutional court as well as a court of final appeal. And
like ours.
Like ours. It's a choice that societies make. And if we have only one Supreme Court, and we have all the complaints about numbers and all of that, think about then having 2 of them. It comes with a baggage. It comes with a cost. And as I have said, it's inconceivable that you can be a master of the technical nuances, smaller laws, but not be a master of the grand norm, which is the Constitution itself. And therefore, in terms of competence and capacity, I think that the Supreme Court, as properly constituted, and if you look at the appointment requirements and all of that, has the competencies to deal with these things across board. Are the jurisdictions too broad and are there too many things? Question is, yes, but can it be dealt with? The court has been dealing with it.
Yes, and it is obvious. Sometimes the judgments, those who are leading the judgments, it becomes obvious to us that because, like Dateba, because he has a lot more competencies in certain commercial, bigger commercial matters. So you find him in that area. So more often he's the one who is leading
Samson, that's
those
not my
judgments.
learning. My learning is that each of these judges have demonstrated, if you go to look at their work, they've demonstrated their competencies across the scope. Okay, I mean, I'm here, and one of the materials I have carried here is Reflections by Dr. Ba,
right.
And these are his reflections as a Justice of the Supreme Court.
Very useful book.
Through it, you will find across the board. You take any of the juries, I mean, from Atugba to Enini Abua JSC to Sophia Kufu JSC to Wood JSC, Doche JSC, you will see that whether it is a chieftaincy appeal, it's a commercial appeal, it's an investment law appeal, it's a criminal appeal, the judges across the board acquit themselves well. Because, Samson, the law, incidentally, is the most integrated discipline that I know of. So, you are on the highway, and there's an accident. Now, you hit somebody's car, the car actually tips over and hits somebody who is carrying goods that the person is selling. The car has a Togolese registration number, probably Togolese insurance. Somebody is injured. Samson, tell me, the issues entailed in this single incident, are there issues of traffic regulations, criminal law, insurance law, international law, commercial law,
conflict of
personal
laws.
Injury, conflict of laws?
Right.
The law is, so you will see that even at our training across the common law, we trained as lawyers. So a lawyer is a lawyer is a lawyer. But in applying yourself in the marketplace, you will then choose where you find yourself to flow with least, but you will not be illiterate in relation to any other aspect of the law. So it's like telling me that you can find an engineer, and this engineer says that, oh, me, I'm good with Mercedes-Benz cars, but when you bring a BMW, I have no clue.
Right.
I think that the way that a car engine functions is the same across cars.
So here is a general question. You have taken us through the lower to the superior courts and clearly demonstrated that there are checks. That is an admission that the courts are fallible. So mistakes will be made at one point and someone else need to correct it. In that regard, why is it, as some say, that the court is aversion to criticism?
I think first of all, it's a wrong notion. So in the structure of the courts itself, it's a direct, it's not even an implied, it's an express recognition that judges, and for that matter, courts, make mistakes. That is why you have a hierarchy. That is why you have an appellate process. In fact, that is why even within the same court, you have a review process. I just referred to the High Court as a prefect of the lower courts. Why do we have prefects in school? Because people will cross the line. People will break some rules, and prefects have to be there to whip them into line and ensure the right thing is done. Similarly, the Supreme Court is the prefect of all the superior courts. And so it holds the same cane and makes sure that people are in line. The reason you go to one judge, the judge makes a mistake, you are dissatisfied. And look at the way the law, the wisdom in the law, in the way things are structured. So you go to a magistrate, the magistrate is sitting alone. You go to a circuit judge, he's sitting alone. You go to a high court judge, superior court judge, he's sitting alone. The moment you become dissatisfied with a decision of the high court and you protest your dissatisfaction by way of an appeal, so you are going up and you are supposed to be going to judges who are more experienced and more knowledgeable. But for the High Court of Appeal to be a court properly so-called to hear your appeal, minimum 3 of these more knowledgeable judges have to sit together. 2 will not do. It has to be a minimum of 3 or 5. Now, if you were even dissatisfied with the Court of Appeal and you came up to the Supreme Court, and this is supposed to be the apex where the grandmasters of the law sit, you go there, the minimum number of them who can sit down and examine what those 3, the one judge did, which went to 3 judges, now is 5. It's a recognition that there can be error, there can be mistakes, But the law provides self-correcting mechanisms that allows those who have the stamina to persist and to push their case, and who find lawyers who have the skill and give attention to detail, etc., to do their work. So the way you criticize a judgment, if the High Court gave you a judgment that you are not happy with, it's not to go to a radio station. It's to take out an appeal, or if you think he's broken a fundamental rule, you invoke the prefect's powers to deal with them. And there is no judge who lives with that with comfort, that something you did is being quashed and described in all of the words that the prefects use to describe your work. So you can first, in terms of your client's substantial rights, protest the judgment, and you can overturn the judgment. Can you imagine? And I'm sure you've had those experiences where you return to the judge and you've just been upstairs to reverse what he did. That in itself is a criticism of the judge's work. Number two, intellectuals, academics write reviews of the work of judges. They review the decisions. They criticize the decisions. Criticism is healthy if it's meant to identify lapses, gaps, failings for the improvement of the system. The criticism, in my view, loses legitimacy if it is intended to undermine, to insult, to bring the court and the administration of justice into public ridicule and contempt. Now, that is also because, you see, something, as I said, at the heart, the soul of an administration of justice is public confidence in the impartiality of the judge and the competence of the court to deal with the matter properly. So the moment you articulate your criticism in a way that you are digging down the court's impartiality, the court's competence, and imputing improper motives, etc., to the court, you are not just undermining the court, you are actually undermining the system that we have all agreed on and said, this is the way to resolve disputes and misunderstandings amicably. Because imagine that we have another election dispute and the protagonists decide that this time round we are not going to go to the Supreme Court to resolve that matter. Where will we be? You think we'll be sitting in this studio? So, with no disrespect intended, we must all, as stakeholders in the administration of justice, examine our motives and never forget, ask yourself, exactly what am I trying to achieve under the guise of criticism? Otherwise, I have said this time without number, and I'll say it here again, Samson, criticism is a healthy thing. It helps people reflect, look deeper, improve, and do things better. And as I have said, I'm here to see a servant who cannot be criticized by your master.
Right.
And so when judges finish their work, we're given to public commentary and we're given to evaluation, criticism. But that criticism and commentary must be within bounds. The bounds are that you are not, under the guise of criticism, digging down and bringing down this architecture we have built as a safety valve for society.
In fact, until recently, there was the review jurisdiction, very limited for a high court judge, where you appear before the high court judge and they deliver a decision and you think that they have made a certain error or some mistake.
And you go back to the same judge.
You go back to the same judge
and point to his mistakes.
Yes, and they reverse their own decision in your favor if they gave it against you. When you spoke about the supervisory jurisdiction, the important aspect of that is that you go seeking that a decision of a lower court should be thrown away, should be quashed. The word you use, quashed. And you must...
When you can point to some fundamental error that goes to jurisdiction, lack of it, excess of it,
right, and
or breach of some rules of
using the word
justice.
Error and all of that is an admission that these are humans and they will make mistakes. In, I think, Republic versus Mensah Bonsu, when the Supreme Court dealt with it, Justice Bamfordado said criticism of the court, however rambunctious, is not contempt of the court. It should be allowed. Why must we make our criticism measured as if we are still fighting within the courtroom,
but also
and not on radio and not in the public space.
Interesting. I was a pupil in those proceedings, but Bamford Addo actually also then said that when it comes to contempt, the truth is not even a defense.
That's true.
So the criticism, which however rambunctious is not contempt, is the one that is intended to point, if you want, to error, to mistakes, to lapses in the reasoning, the analysis of the facts, the conclusions of the court, without seeking to insult, deride, ridicule, and bring the administration of justice and the court. And you see, I'm very careful. I'm not talking about the judge.
Complete quotation of what I reference has that as well.
Exactly. So I'm not even talking about the judge, because the powers of contempt of the court are not meant to protect the judge. They are meant to protect their court. Okay. And the judicial officials, the court's processes, and that we have all agreed on. Something, the simple thing is, look, criticize however violently you can, but watch the red line. The red line is when your criticism tends to amount to deriding, abusing, ridiculing, bringing the administration of justice into disrepute, into public ridicule, into contempt, into hatred and disdain. You have left the realms of criticism, rambunctious criticism, and you are now in the realm of trying to dig down our safety valves. And that is where the law will clamp down on you.
You're still here on the law. This is your legal light. It is your health law. And we are getting into an aspect that you are concerned about. You sent quite a number of questions about. And someone actually said, there's an obvious and emotional aversion of the judiciary to unanimous FC. If that is the person's choice of how to criticize a decision which has left the court has become functus officio, and the public is entitled to criticize it, why dislike it that much?
I don't think that anyone dislikes unanimous FC. It is the contextual use of the unanimous FC that makes it an applause or an insult or a statement in disdain meant to demean and undermine the judges and their independence when it comes to their judicial thought. When you use that term in the context where you are suggesting that these judges do not have independent judicial minds to make up minds of their own, it is not a positive use of the term. It's a term that is used in a way that will deride the court. Okay, that you suggest that something, I joined the Supreme Court not to express my thoughts and my thinking, and that the oath I took, standing alone and holding the Bible and swearing to God, I did that to go and append myself, just run with somebody's thoughts. Now, why is it that we go from one judge to two, to three to 5, or 7, or 9? The reason is, as the issues get more involved and get thicker and get more contentious, human learning and wisdom is that more heads are better than one. That's the reason why you now, it's as though the system is saying, even though you are more experienced, more knowledgeable, you went through a more rigorous process we can't trust one of you as we did even with the smallest judge. It is because the law in itself has an implicit recognition of shared wisdom and knowledge. They say tiku and kojina.
Correct.
You know, and the two heads are always better than one. Now, why must we think that the law put the 3 judges together not to find common ground on what is fair, what is just, what is conscionable, what is the proper construction of the rights of the parties? and resolve the matter in unanimity, but that the law put the three together to disagree with each other. It is because of our negativity. And so, you are a lawyer. When you pick a decision, that is a collective expression of the shared wisdom, unanimously, of all the 5 judges. And when you pick one, which is a 3-2 decision, Samson, the law is the law. It doesn't take away from the fact that this is a judgment of the court.
Right.
But when you are citing that decision, it's for purpose that you will never miss the opportunity to say that this is a unanimous decision of this court. Because contra views always show that there's another way one could look at it. And that is very healthy, and the law allows that. But I think it's very subversive of the whole system of a peaceful adjudication of disputes. If we are people who are more welcoming and want to have our highest court made up of elements who are always in disagreement with each other, first of all, when we looked at why we have courts, we say we have courts so courts can give clarity to the law. Is the law clearer when we speak in unison together or when we speak in separate voices? Have you seen a choir that when somebody is singing this way, the other person is shouting the other way? They will produce very good music. So those people who hold this criticism and use unanimous FC in a negative connotation, that's what they are advocating for. But unfortunately for them, I mean, the elements, by the time you get to that level, nobody subjects your views to another. And if you have the conviction and good reason to dissent or disagree, you will do so.
Right.
And you will see that the decisions are replete. I mean, I have had convictions, I've had convictions, I've dissented in decisions. But when I see wisdom, and I see that this is a superior enunciation of the law by some of my colleagues, I must dissent to show that I'm here to disagree with everyone for the sake of disagreeing. That will not be wise. That will not be constructive. That will not be progressive. That's not going to advance the cause of justice. So where there is a need, and something, it will amaze you. Let me give you a peep what happens in a standard, in our normal conferences.
So that's where we're going to come to how you arrive at your decisions.
Yes.
And reading Justice Dr. Bayer's book, as you have brought in the studio, gives good education. So how do you come to that? So that we don't, because we are friends, we know each other somehow, we agree that for this case, let's go against this person.
No, it doesn't work like that. Look, Samson, so this is how your servants work. We convene in the conference room. So prior to the conference room, the cases are assigned. So the courts are empaneled, cases are assigned. The dockets and the work is assigned to each judge. And between when you receive this and the hearing, you read, you research, you make up your mind. One way or the other, conclusively or inconclusively. But our pre-sitting conferencing, when you guys are waiting in the conference room, is that we're in that room, and in relation to applications which they don't abide time, is that the routine is of the 5 judges, and as you know, seniority is a very important thing for judges. So when you see us walking, even the way we walk in order of seniority. It's such a protocol of order and due process that we live it. The way we walk in order of seniority. The way we sit in order of seniority.
That's right.
The way we speak in order of seniority. Now, so the most junior judge will be the first to address the case in conference, and we are all round one table with the presiding judge. The most senior presides, who is the president of the court. So, what does my lord so and so? So you will give your sense of your synopsis of the case, the facts, the issues, the law, the evidence, and what conclusion you will reach. You don't know what anybody is thinking and what their positions are.
All right.
Then it goes to the next Monsignor. We come from bottom up. He says, I don't agree with my brother Kulendi. And on the facts, I note A, B, C, D, which doesn't seem to engage his attention. On the legal issues, I will think X, Y, Z is the issue. In terms of the evidence, we saw this, we've seen that. Have you seen this affidavit? Did you pay attention to paragraph so and so? I have looked at the case of so and so, and this is what we decided, X, Y, Z. For these reasons, I don't agree with my brother Kulendi. I would decide differently. Okay. Then it goes to the next judge. He says, I agree with my Lord Kulendi on the facts, or I agree with my Lord so and so on the facts, on the law so and so. I also think A, B, C, D. Moreover, I think X, Y, Z. In any event, if you look at this and you look at that and you look at that, I am more inclined to agree with my brother Samson and on this point. Samson, you already have 2-1 in the bag. Then it goes to the next person. The next person says A, B, C, D, X, Y, Z. In fact, I always laugh at the president is supposed to be the most senior and the most powerful. If you are not lucky, by the time it gets to the president, the votes are cast one way or the other. Now, there are occasions you are unable to agree. And you see that it's a more involved argument and issues. And it's getting hotter. So we'll agree, we'll come out. That's when we adjourn. And then we'll set a date for judgment conference where everyone then prepares. And you come back to reiterate your positions. Sometimes we'll agree to exchange drafts.
Right.
So put those who think this way, put this in writing. Those who
That's
think
how
this
come
way,
someone will say, I have seen my brother, I have seen my sister.
And I agree or I disagree.
Okay.
I mean, we've held positions and then, look, and then you change your mind and say, no, I'm no longer of this position. We've even had experiences. I've had experiences where, I mean, you are tasked to write, or I offered to write. After I wrote, another colleague says, I'll write a concurring opinion, etc., etc. So he is writing the concurring opinion to support mine. When I saw his concurring opinion, I thought that it was a more elegant, succinct, and superior enunciation of the law than what I was putting forward as the lead opinion. I stepped down and said, no, we should use this opinion as the lead opinion. That's the kind of environment in which we work. Now, Samson, at that level, nobody goes there to go and subordinate your ideas and your thinking to another judge.
All the years of
court, all these years, I left practice. I took this oath I call of poverty because I want to serve, I want to create a legacy. I'm going to do, you're not going to achieve that by going to follow unexamined ideas because, look, as you know, we read judgments and decisions that were written many, many years ago. And even as law students from first year, you start criticizing the judges and their work.
That's right.
That's the kind of future that awaits us. So we don't take the responsibility lightly at all. Now, will judges have inclinations, motives, interests, etc., etc.? Of course, because judges are human beings. That's why in some jurisdictions, if they strip you bare, they want to know. I was asked what my what judicial philosophy is. I mean, I don't mind. I'm not a slave to any of these schools of thought. For me, at the end of the day, the ends of justice are that the outcome must be fair, it must be conscionable, it must be equitable, and it must be just.
Thank you very much. Please hold it briefly there. And you've been listening to our very special guest, Justice Yonny Kulendi of the Supreme Court. And this has been the second installment of our legal education about the courts, how they work, how they are constituted, and how they work. This is the law. It's your legal light. It is your health law. We will open the phone lines very soon for you to join us with your questions. And as you know on this show, this is a legal clinic. So your questions must be about the subject and put in a manner that I will admit. Thank you very much. And those of you who are sharing some already, I have them, including those of, I don't want the lawyers to hijack the show. So lawyers asking questions, I'll exercise my discretion and bias not to ask your questions, but to defer to the questions from our viewers. So you can tell that we have an extended edition. We have been granted some 30 minutes that we will continue with this discussion because we have a special guest dealing with very important issues that deal with the core of our democracy and the survival of this particular democracy. He said the courts are actually the glue of stable society. But how accountable are they? That's why we're interrogating these matters. So once again, and okay, I'm being asked to break and take the calls right now, but I wanted to have you, this is at the Supreme Court.
Right.
What a beautiful way in which you come to a decision. How about the other courts?
Right.
How do they come to their decision?
So,
civil or criminal?
So the Court of Appeal will work in plus minus the same way. That's the whole essence of the panel system, that people can put their heads together, etc., etc. So in a properly, and I have no reason to think that the Court of Appeal functions differently. That's the way that it should work, just as we do in the Supreme Court, where there's debate, there's banter, there's push, pull. You must persuade your colleagues to carry their endorsement of whatever view you are urging. You may come with motivations, Samson, but unless you can intellectually persuade your peers, your colleagues to come along with you, your motivations will fail. And as I can't overemphasize the fact that nobody at that level is there to mortgage their standing, their image, their reputation, their legacy to another person at all. Now, when it comes to judges who sit as single judges of the court, something you are, to a very large extent, on your own. But in the way that we are trained and taught as lawyers, I call, when I was in practice, I call other lawyers, I call senior lawyers, I call junior lawyers. In fact, I used to have, at my personal level, a checkbox. I'll have to speak to somebody at the top, speak to somebody a little down the ladder, speak to somebody at my level, speak to another 2-3 people below my level before I reach a conclusion. So if you are a judge and you are a single judge, unless you think that as for you, you are imbued with the wisdom of Solomon, when your senior brothers and sisters above your head have the benefit of sitting in panels and consulting each other, and yet run the risk of error and mistakes that lend them to public criticism and rage, but you decide that as for you, you box yourself in. I wish you God's guidance, but you must research. Everyone has their, confidence circle of people who, they will not tell you because your judicial oath and code of conduct doesn't allow you to pre-discuss your case specifically with another person.
Yes, I was going to ask about that because you're supposed to exercise independence of mind and thought. So what is this thing about consultation that you are urging?
No, consultation by way of research. By way of putting together the materials and the information that you need to illuminate and enlighten you so that when you independently reach this decision, you don't reach it inside a ditch or in mud that will stick on you the rest of time.
We'll come back to that. We'll take a quick break. We'll be right back. You're welcome back. This is The Law. It's your legal light. It's your health law. And we're thankful to the Chief Justice and the judiciary that we have Yonny Kulendi, who is also a Justice of the Supreme Court, here helping us to understand how they work. And now we're dealing with how they deliver, they reach their decisions. A number of you have questions. Our phone lines are opened. You can now call in and ask your question. First of all, Okomensa says, I want you to ask His Lordship Justice Yonny Kulendi why public confidence in the court system is at all-time low and how can it be corrected? Before that question, because I had asked you about the sole judges and their decision-making process, yes. There are people who want, when they come to court, they want the judge instantly. It's an application. There are things they want instantly. They want to hear what the decision is. But you seem to encourage a lot more research and time before you deliver. That will also constitute part of what there will be delays. You don't agree?
Something is a yes and no. Okay, now, of course, justice delayed. The cliche is justice denied. But justice rushed can also be justice denied. I think that judges should deliver expeditiously, but not compromise efficiency, rigor, and thorough outcomes for speed. Because the decisions that judges render affect people in their peace of mind, in their pockets, in their property, in their rights, in their liberty. If there's anything that you should be slow to do, it is reaching a verdict.
Okay.
In the proper scheme of things, Samson, the judge should have the benefit or opportunity and the space to thoroughly read the papers and all of the processes filed and do his research, process his mind, and come to sit down and listen. Now, there are definitely applications, issues that come up that warrant what we call bench rulings, where the judge doesn't need, the judge may rise and go to his chambers if he wants to put his thoughts together properly. I think it's a legitimate criticism that sometimes judges unnecessarily adjourn and postpone decisions and rulings. But it must also be said that judges have a responsibility to be thorough and rigorous and very thoughtful and careful in the verdicts that they render, because the same public that is pushing you to render a hurried justice are the people who will take you to the cleaners and not excuse you for oversights on your part because you have overlooked some matter which is crucial. And as I said, every decision a judge renders, right from the is appealable. They can invoke the prefect's powers over you, etc., etc. So judges ought to be careful.
Let me. Okumensa's question. I'll come to that because he typed it. It's available. We have Kwame on the phone lines. Kwame is calling us from Ashaiman. Hello, Kwame.
Hello. Good afternoon.
Good afternoon. Please go ahead with your question.
Yes, please. I want to ask His Lordship that because of this unanimous decision perception that we have, outside the court, the Supreme Court judges, how do they relate among themselves?
How do they do what? How do they do what?
How do they relate?
Relate. Okay.
Among themselves.
Okay. Thank you very much, Kwame. Right. Thank you. Right. So we've noted Kwame's question. So we can go to Okomensa's question.
Okomensa says... So Oko's question about public confidence. Now, yes. Oko, I think that, to say that there are no issues of public confidence in the administration of justice would be over complacency and some kind of pretense. But I think that there are very obvious and objective reasons why we have that state of affairs. And one of the reasons is why I'm sitting here, on a Sunday before live TV and taking your questions. There's a thinking that our masters, the Ghanaian people, don't understand exactly what we do, how we do it. A lot of them do not understand the rules that they themselves have imposed on us. You know, the work we do is called due process. Due process means it goes to, you must take time, you must check all of the boxes. Procedure is as important as the outcome. And woe betides a judge who is rash and doesn't take their time. But if the people don't understand this and don't understand that when you adjourn a matter because you do not find yourself your mind sufficiently made up to render a verdict, it is because you want to be sure that you do justice to the two parties according to your conscience and your convictions, that you have not overlooked any material matter that you should overlook. And therefore, the lack of understanding about the processes and how we work is a contributor to it. Number two, the system is choked. As I keep telling you, even though we have, 125 high courts, 105 circuit courts across Ghana, 178 district courts, there are still no courts around. I mean, I come hail from one of the new districts to date. And this is almost, almost over 8 years, going 10 years. We still do not have a district court in my district. So how do the people access justice? So the issues of delay breeds suspicion. It makes people raise queries. Now, and there's an issue that nobody runs away from, that the judges, being part of our society, in spite of the rigorous processes for judicial appointments, etc., just like we have Ghanaians who work themselves into policing because they think policing is an easy way to extort and make money. Some want to go to immigration. Every young man who comes to me wants to go to immigration or go to customs or go to police because they see these as easy sources of extortion and self-enrichment. I have enough common sense not to think that judicial work is a safe sanctuary, that we don't have people with the wrong motives who have wormed themselves into judicial office, right from the court clerk to the messenger to the bailiff to the registrar to judges. You can't speak for everyone. And you know, our society is very incestuous. I always say Ghana is like a compound house. So the man who bribes the judge tells his wife tells his neighbor, they tell another person, and they assume that maybe every judge can be bribed. But what I can tell you for sure is that much as they may be bad, there are bad nuts amongst us, who hopefully in the course of time we will find out. Some may find the kitchen too hot for them, but there are also very genuinely people who believe in the cause of justice,
right,
and will do everything to ensure. They may make a mistake,
right,
but it is not for some motive.
Thank you very much, and I'll get my law to also educate you how to report some of these things. The few occasions where you encounter that there is some bad thing happening, how to report and to get the system itself take care of those who are doing wrong. Emmanuel, you are calling us from Kumasi. Please forgive us for keeping you on the line for a while. Hello, Emmanuel.
That's fine, Samson. Good afternoon.
Hello, go ahead.
So that comes to, your last submission comes to my point that, justice is expensive in Ghana. So assuming you show that a judge has been biased against you in judgment, apart from it, let's say maybe for a magistrate court, apart from going to the high court to go and seek a correction of his judgment, is there any other place that you can go at a lower court? Maybe is there any other institution where you can report that I'm sure that this my judgment against me is highly biased, that I don't have money to move to the high court. So can any that institution listen to or take the proceedings and everything and go through and check that indeed the judge erred? Two, court registrars. Are they lawyers?
Emmanuel, the appeals are to impugn the judgments. But if a judge puts up a conduct, that conduct which you deem to be misconduct, then you can report for sanctions. But to have the judgment appeal and then also, okay, let's hear what my lord will say. Yes, quickly wrap up.
Yes. So my last one, can a court registrar, turn herself or himself to advise a person who has petitioned against the other party guiding the person, what the person should demand, everything. Because I have a case where, like a divorce, the woman went to the court. It was the court registrar who said that the woman should allow them to insert a lump sum of compensation in the case, even though the woman knew the reason why she was leaving the marriage and said she didn't want anything.
All right.
The court registrar advised and pushed her to put in a money, where later they were able to enforce that money on the person.
Thank you very much. And these are important questions, two of them that are outstanding. So can you hold on with the calls for me a bit so that I can have my Lord respond to them? So I think we should begin with Emmanuel from Kumasi. What can he do beyond an appeal?
No, so there are matters that relate to your experience in court that the only way you can correct it is through the judicial process. Because you see, when a judge, and that's what we must all understand, when a judge sits as a judge, doing their work as a judge and exercising their judicial mind, the only things that control that judge are the facts before him, the evidence, the law, and his or her oath. Any judge properly so called, and his God that he swore to, that's the only thing that weighs on the judge's mind. No other person, not the Chief Justice, not a Supreme Court judge, not a president, not a politician, nobody controls the judge. The judge is free to reach with his independent mind the conclusion that he thinks is borne out by the law, the facts, the evidence that has been urged on the judge. So as far as your complaint relates to the judge reaching a conclusion you think is wrong or not, the only way you can correct it is to use the law.
Okay.
Now, but if administratively the judge engages in misconduct, assuming you see the other party going to the judge's house, or you see the person go in there with a goat, or carry some load into the house and come back out without it, those kinds of improprieties that are unbecoming of a judge, you can make an administrative complaint to the Chief Justice, and that judge will be made to answer. You can write a petition, the judge will be made to answer. The judge can be taken down in disciplinary proceedings and dealt with appropriately. If what you call bias is bias in the sense that the judge has reached a conclusion that you don't like, if it's a judicial conclusion, you can only use judicial means to correct it.
Another part of it is the role of a registrar.
Yes.
A registrar appears to have assisted
so let me answer
a party.
Listen, Emmanuel, if it depends on the court where you are. If you go to the magistrate court, because a lot of us are legally, functionally illiterate, and the law actually wants to make justice and the processes accessible to practically everyone. When you go there, the sermons form, the person who will help you to complete it is a registrar or one of the staff of the registrar. So if you want, the registrar literally is like he is your lawyer, because you know, you go to a lawyer, and unfortunately for us, the lawyers are just some of us the same Ghanaians. They like money. They think they went to law school just to make money. We, unfortunately, wherever we are as Ghanaians, we don't believe in service. We believe in money and self-enrichment first. So you depend on the system. So the registrar, in, of course, helping you to complete your sermons, will have an opinion.
Exactly.
Because he thinks that you don't know that you can claim maintenance or you can claim a financial provision. He's at least is responsible.
So a registrar
for the
assisting a party
to
that way.
make those suggestions to you.
There's nothing
and
wrong.
there's nothing wrong. And that will not compel the judge to give it to you unless you deserve it.
Okay.
So there's nothing substantively wrong with the registrar playing such a role.
Right. So as you know, not everyone can afford the services of a lawyer. And sometimes these registrars are there. Here we have given you that education over and again. When you have an issue and you can't afford a lawyer, don't give up. Walk to the court closest to you. Ask to see the registrar. They just may help you. Now, the first question came from Kwame in Ashaiman. How do judges relate? How do you relate? Particularly those of you at the Supreme Court.
Oh, no. I mean, look, by the time you get to that level, look, we have a problem before us that we are trying to resolve. And the reason the law puts us together in those numbers is to bring as many perspectives and understanding and counsel and wisdom to bear on a resolution of the issue, so that what will happen? So we will do justice between the parties. So when we put our respective ideas and argue and push and pull and we reach a verdict, that's the end of the matter. You, the judge, you have no personal investment in the matter beyond your convictions and the ends of justice. And the end of justice is a judgment that we agree on. So whether you are in minority, you are in the unanimous FC, you are a lone dissenter, it's fine. We have the sophistication to understand that this is work we are doing. As I said, we are just glorified servants trying to do our best to resolve matters amicably between the parties. I mean, unanimous. Have you ever seen any Supreme Court who, after they resolved the matter, a group of judges went to take the seats in Flagstaff House or the Old Castle? No. You resolve the matter for one person or the other and say that according to your conscience, the evidence, the issues, this you think is the fair and just conclusion supported by the law.
Right. And one of the questions that was common among a number of questions we received after last week was delays in the courts. We have seen the CJ moving around, meeting with courts staff and urging them to see how the court can be more efficient. In fact, and I'll make a confession, I had a matter I hadn't attended to for a while. Not too long, but I'm used to the system that way. I showed up in court and the judge said, by the CJ's fiat, your case has been struck off.
Yeah.
You must go through another process to resuscitate it, pay money, and if you mean it, you must make sure you are prosecuting your case. Delays.
Yeah, delays are a big problem. I mean, but it has causes. Some of the causes you can attribute to the court, to judges, to lawyers, even to litigants. Others you attribute to the system. If there are too many cars on the road, there's bound to be traffic. Okay, and it takes time to pull through the traffic. So we have too many cases, and that is very interesting that the same Ghanaians who are losing confidence in the courts keep stampeding the courts with a lot of disputes. I see that as a positive thing, and it's an endorsement of confidence. Now, so too many cases brings about delay, but bad driving also brings about delay. At the level of, if you want, at a certain level where there are no lawyers involved, you can attribute the delays to the litigants themselves, the judges, and the court officials and court processes. When lawyers come in, as you go up, lawyers become part of the delay factor because lawyers themselves, either they overplay procedure or they themselves, they are not focused or they are not very diligent, and because you have hired them as an agent, I mean, there are cases you will see, you ask yourself, what has this lawyer been doing all this while? But there are also cases you will see, you ask yourself, what has the judge been doing all this while? But there are also cases you will see, you ask yourself, what has this litigant been doing all this while? Because after you went to instruct the lawyer, what happened? You left the matter with the lawyer and go home and sleep and forget about it. The lawyer has many clients. Every day somebody is knocking at your door. And if he's a lawyer who is quick to take money, when he takes your money, he wants the next man's money. So you put pressure on the lawyer and demand that the lawyer does their work.
Right.
If you have your case before a lone judge at that level, make sure you are always in court and keep pushing. And if you go to court a certain number of times and you feel your case is not getting traction, and you think that there's a deliberate delay by the judge,
and in respect of delays, Alhaj Suleiman says, what does the Supreme Court intend to achieve whenever they delay a matter that is time-bound, but still go ahead to give a ruling that may at best only have futuristic implications, like the decision in the Daniel Domilovo matter?
Now, so the Supreme Court doesn't delay matters and give decisions. Look, you have to look at the men and women you put in these courts. Okay, they are not people who are not serious people, and they are not people who are not focused. They are all people who get there because they are actually achievers and people who perform. They are high performers among their peers. That's how they get there. There's no other way. And you can't suddenly get into the Supreme Court, and the reason you are there to self-actualize, you begin to pussyfoot with it. But as I said, a lot of the time, you have delays because the judge the lawyers who issue the writs and file the processes, after they bring it, they file the initial processes, they fizzle out. They don't follow through to file the other processes that you require in time to get the matter to be heard. Look, we've been considering actually now awarding costs against lawyers for causing delay. But if we do that, the lawyers will turn around and take the money also from their client. But any idea that the court has an orientation to delay matters and give the decision when it is not relevant. In fact, the consciousness in the court that I belong to is the opposite. But there are mechanics of due process. If you file a process, you must get the process served.
Right.
If it takes you 1 month to serve a process, you could serve in 2 days or in a day. It doesn't come even to the judge.
Right. And we get feedback immediately. Oko Mensah says, thank you for asking His Lordship Emmanuel Yonny Kulendi my question on low public confidence in relation to the judicial system. I must say His Lordship did justice to the question. I am now better enlightened and educated. Once again, thank you for this good work. My Sundays are not complete without the program, The Law. Now, there are those who say, and we have just about a minute to go, that at the Supreme Court, elsewhere, in the US, for example, they serve for life and they have the best of researchers. The best of Harvard is giving to them to intern with them, help them. But here you are, you must do everything on your own. How are you able to churn out the work you churn out?
Yeah, so those are some of the challenges. I must say that lately, I mean, there's some improvements. We are not there yet. The Supreme Court judge in any of those jurisdictions usually has a full secretariat of intellectual support that does the research and generates drafts, health review, material, etc., etc. We have some minimal research support, but is it enough? No, it's not enough. If you go read Her Ladyship the Chief Justice's statement on her investiture, you will see her shopping list that she told the good people of Ghana. If you want us to do this, we will require this. If you want us to do this, we require resources. If you want us to do this, we're doing our best in the circumstances, no complaining, but we can do better. I mean, a lot better. And for more efficiency, we've got to put in more resources, put in more intellectual support, put in more research materials at the disposal of judges so that the judges can deliver as they ought to.
Thank you very much. Your Lordship, Justice Emmanuel Yonny Kulendi of the Supreme Court, who has been helping us in these 2 weeks on Court of Competent Jurisdiction. I suppose you have been educated to the extent that you know how the courts operate, give their decisions, or arrive at them. You are better empowered to make certain decisions for yourselves, as far as the court is concerned. Thank you very much once again.
Samson, I'm grateful to you and to the audience for the privilege of service.
Right. Forgive me, my colleague lawyers who sent in all your messages that I ignored. It's for the people. I'm Samson Lardy Anyenini. This has been The Law. It's your legal light. It's your help law. Have a good afternoon.